So welcome everybody. Good morning. Good morning. My name is Dana Sparks, and this is the Real Estate Academy of America as the school. And today's class is License Law for Agents and Brokers. This is the class that does satisfy Greg's license law requirement. So we are just going to dive in. I have everything that you need on the PowerPoint. So I am just going to dive in. It should answer all of your questions. If you do have any questions, then feel free to type them in the chat. And I'm glad everybody is here with everything going on in the news today. And I am recording this. We haven't recorded, but it's been a while. So I am recording this live, and this is March of 2024. But I will tell you, since license law as a CE class is required by the Georgia Real Estate Commission, that means that every school that offers this class must cover the same coursework. So, an instructor is able to, of course, put their own emphasis or their own examples on things, but it is in license law covered the specific parts of license law that my class, as well as any class offered by any school on license law in Georgia, must cover. So that being said, let's dive in. So I'm going to share my screen, and everything you need will be on the PowerPoint. So, and I have to put my glasses on. All right. So as I said, this is license law for agents and brokers. It is Georgia Real Estate Commission course number 65208. We cover the official code Georgia annotated. These are the law books for the state of Georgia, are all covered in these books. These are our trade laws, our criminal laws, our civil laws. Everything is covered under some sort of code in the Georgia code. But for what we're covering today, it's 43-40 as well as GREC Rule 520-01. As I mentioned, it does satisfy Greg's license law class requirement. I am the instructor. My name is Dana Sparks. I am the qualifying broker of Maximum One Greater Atlanta Realtors, as well as the director of the Real Estate Academy of America, which is Greg School 6915. For the notice to students, this is a virtual or remote broadcast of an approved in-class course, 3 hours in duration and approved by Greg for CE. No prerequisites and no homework or required written exam. Again, I'm the instructor. The way we do attendance is you must be, for any CE class, you must be on time and present for all classroom, remote, or virtual broadcast instruction hours in order to receive credit for the course. The way we do that through the virtual course for the Real Estate Academy of America is via the chat function. Now, additionally, the Zoom programming does keep track of who registered, and it keeps track of your attendance electronically via your computer or your cell phone or however it is you are watching this class. But for the attendance feature, we also do it via the chat function. So what that means is I am going to ask you 3 times. If you've already done so, you do not need to do it again, but I am going to ask you to put in your name, license number, email address, and phone number at the beginning of class, when we come back from break, and right before you leave. Additionally, there will be times throughout the class I'm going to ask you questions. Some questions are rhetorical and don't require a response. Some questions I am going to ask you to type in your answer in the chat. Even in the interest of time, if I go on and give the answer to that question, please go ahead and type in your answer. That way we can demonstrate that you actually were in attendance of the class and you were paying attention and answering the questions, and you didn't just turn on your computer and walk away for 3 hours and come back. Students may, additionally, just generally speaking, you may not take more than one virtual simultaneous classes or two simultaneous classes with overlapping times, regardless if they're offered through one school or multiple schools. If student attempts this, student will not receive CE credit for either class. I mean, just think about it. If it was an in-person class, you can't attend two separate classes simultaneously, and you can't pay attention to both classes the way that is required. Students may only receive credit for a specific course number once every 12 months. If you've already received credit for this specific course number or any CE class, you are always welcome to continue to take the class for the information and knowledge, but you only get credits per your license once every 12 months for a course number. And there is no recruiting for employment opportunities for any real estate brokerage in this class or on school premises. If so, please report promptly any effort to recruit on behalf of a brokerage firm by anyone, including a fellow student, to myself. I'm the director of the school, and there's my phone number, or to Heidi Kelly, who is the coordinator of our school, or to GREC itself. All right. Now, as a reference for license law, again, it is the official code Georgia annotated, or you will hear that referred to as Georgia Code Title 43, Chapter 40, as well as GREC Rule 520-01. You can access these bodies of law. You can just Google OCGA 4340 and you'll get the entire body of law. And you can go to GREC's website and look at the GREC Rule 520-01. As I mentioned at the beginning, I'm not going to cover the entire body of license law, or we would be here for days and months. But there are specific portions of the license law that GREC does require any class that fulfills this license law requirement to be covered. However, you as an agent, you are responsible for the entire body of license law that governs your real estate license issued to you by the state of Georgia. Additionally, I do have handouts that I'm going to cover on the slides, and at the end I will show you where you can access the handouts as well as a PDF copy of the slides. The text on the slides is abbreviated to make sure that they do fit on the slides. And as I mentioned, all licensees, you all have an independent, you're independent contractors. You are all responsible for your own licenses, even though you cannot practice without that license being held by a firm recognized with GREC that does have a qualifying broker. But you are all responsible for reading, understanding, and following Georgia real estate license law, again, as written in the entire Georgia Code 4340 and the entire GREC Rule 520-1. Today, what we're going to talk about is information about the Georgia Real Estate Commission, effects of prohibited conduct on your license, requirements to transfer to another firm, requirements for handling escrow funds, unfair trade practices prohibited in Georgia, broker relationships and handling transactions. That doesn't mean how much you like your broker or not. That has to do with the relationship between your public buyers and your public sellers and the broker. That's the broker relationship. Management responsibilities for real estate firms, advertising rules, and licensees acting as principals. Now, as I've already mentioned, because we're covering there are two bodies of laws where our license laws are housed, the Georgia Code and the GREC Rule, as well as some of these other finer subdivisions, for example, effects of prohibited conduct on your license, unfair trade practices, so forth and so on. There is a lot of overlap. What do you mean by that, Dana? What I mean is there is a topic that is covered by the Georgia Code and by GREC, and even within the Georgia Code, it's covered, for example, under the subsection of effects of prohibited conduct on your license, and again addressed under unfair trade practices. Why am I telling you this? Well, I'm telling you this because there is a lot of information in this class, and there is a lot of repetition. However, when I get the first time we cover a topic, I'm going to cover it pretty in depth. We'll have a pretty in-depth discussion about that topic. However, when we come up with that topic again, I'm going to go a little quicker because I will have covered the main tenets of what you need to know regarding that topic. It's just couched under a different portion of the law. This will all make sense in just a little bit. So first, let's talk about the Real Estate Commission in and of itself. This is a government body. This is a state-sanctioned body, hence Georgia Real Estate Commission. And what do they do? The handout that I will share with you is, I will show you this on the screen. This is information about the Real Estate Commission. And this information is available to you through GREC's website. And basically, this is what they do. They administer license law. They are a regulatory body. And this is, again, information about what they do. I'm just showing you this, and I'll show you some of these other things as an example of that the handouts that are available to you, and I'll show you where to get them at the end of class, what they all are, but I am going to cover everything in the PowerPoint. So let me go back to the PowerPoint. So again, the Real Estate Commission, they do administer license laws that regulate brokers, real estate salespersons, and community association managers. Now, GREC is also the governing body that governs our appraisers in our state. But today's class is not about appraisers. They also are charged with protecting the public interest as well as enforcing the laws fairly and impartially. I'm going to give you a hint. Remember that GREC's one of their primary purposes is to protect the public interest. I am telling you this because if you are ever in a situation or have a question, whether or not an issue or an action or disclosure or lack of disclosure is a violation of license law or not, and you can't remember the specific license law, if you just ask yourself, is this protective in the is this protective of the public interest? If the answer to that is no, then it more than likely is a violation of license law. If the answer to that is yes, this is very protective of the public interest, then more than likely it is not a violation of license law. Again, that's just a gut reaction, a predominant question to ask to start your questions, to start your search. If you have a question. All right. Now I'm going to start with a quiz. I told you there's no test, and this is going to be a quiz we're going to do together, so it's not graded. But this is a great starting point. So here we go. I can name the 7 federally protected classes of the Fair Housing Act. So everybody in the chat, type true or false. And I'm just going to tell you right now, in about 5 minutes, that's going to be true for everyone. So everyone, you get a free pass on this one, and you are allowed to type true for this one. True-ish, I like that. All right. All right, next question. Your original real estate license wall certificate must be held by your broker. True or false? Your original wall certificate, that pretty piece of parchment you got, must be held by your current broker. True or false? See a couple trues, a couple false, one false. The answer is true. So I'm going to cover more in depth where all of these are part of license law. And when we get to that section in the law that covers this, I'll go more in depth with the explanation of this. Licensees who have moved from one firm to another are entitled to continue working on pending sales from their old firm. True or false? In other words, you were with one firm, you got a deal under contract, you left that firm before it closed, and your license is with another broker. Are you allowed to work on the deal you left with the pending transaction you left at your old firm? True or false? Some of y'all are just waiting till I give the answer. I see a mixed bag here. The answer is false. Now, there is a ... or a however. There are certain circumstances, some certain issues and items that need to fall in place in order for this to happen. So I'll cover this more in depth when we get to that section about licensees transferring firms. Agents who own rental property may hold security deposits in their own business bank account. True or false? Correct. The answer to this one is absolutely false. Now, there is a certain circumstance where an agent may hold a security deposit in their own trust account, but absolutely it is forbidden if your broker allows it for any agents to hold, even for a broker, to hold any type of security deposits in a business account. A broker may never pay a commission to a non-licensed person or entity. True or false? Seeing a lot of truths. The answer is false. This one's a trickeration one. What do you mean, Dana? We'll wait till we get to that section in the license law, and you're going to say, oh, I can't believe it, Dana. I wasn't thinking. You did trick me. I wasn't thinking about that. So this one is going to come to light towards the end of class. Licensees shall place earnest money into the custody of their broker within 3 business days. True or false? Seeing a mixed bag of answers. Anybody else? The answer is false. The answer is false. License law says you must place earnest money into the custody of your broker as soon after receipt as is practically possible. Now, your broker, however, may have a policy, so your broker may have an additional policy regarding the 3 business days, but that is not license law. And this is covered in 2 portions of license law that you'll see when we get there. Next question. A broker who disperses earnest money contrary to the terms of a contract can be deemed incompetent by the commission. True or false? Yes, that one is true. You have to disperse earnest money per the terms of the contract that the buyer and the seller agreed to. Agents are allowed to collect commissions and or fees from someone other than their broker at any time. True or false? False. You guys got that one. All right. Failure to include a specific expiration date in a listing agreement is considered an unfair trade practice. True or false? Yep. The answer is true. You must have an expiration date in a listing agreement. Fees being paid for referrals must be disclosed in writing to the principal. The principal is the person being referred, buyer, seller, landlord, tenant. Fees being paid for principals must be disclosed in writing to the principal when he or she is being referred for real estate services or relocation. True or false? You guys are all correct. You're saying true. However, my question is, are you doing this? Fees must be disclosed in writing. In other words, when you send a referral and you negotiate what percentage of that commission you're going to get for that referral, are you disclosing that to the person that asked you for the referral in writing? I'm going to cover in this class the law that covers that, as well as some documents and some forms that will help you make sure you stay in compliance with license law. Acting for more than one party in a transaction without the express written consent of all parties is considered an unfair trade practice. True or false? Yep, the answer is true. That sounds like what? It sounds like dual agency. Dual agency in and of itself is not illegal, but you must have the express written consent of all of the parties. Agents must provide a copy of any document utilized in a real estate transaction to any individual signing such document. True or false? Yep, that one is true. Please make sure your brokers, your attorneys, and your lenders also get copies of everything. An agent may rebate a portion of their commission to a client or customer after the sale closes. You can rebate part of your commission after the sale closes. True or false? Mixed bag here. The answer is false. You absolutely may. License law allows you to rebate a portion of your commission to anyone in the deal. So either broker / agent may rebate a portion of their commission to their client, to the other client. However, it must be on the closing settlement statement. And there are a couple of other caveats, but you may not do it after the deal closes. An agent's assistant may do anything an agent is allowed to do as long as the agent and their broker supervise that activity. True or false? Correct. This is a little tricky one too. The answer is false. It depends if that assistant is a licensed assistant or an unlicensed assistant. We'll talk about that later. All advertising by licensees must be done under the direct supervision of their broker and in the name of the firm. Correct. That is absolutely true. How'd y'all do? Pretty well. I think some of you are glad you're here in this class as a refresher, and we are going to dive in. So the first thing that we're going to talk about is what is in Georgia Code Title 43, Chapter 40, 15E and F, and it is part of what is considered prohibited conduct on your license. And generally speaking, grounds for suspension or revocation of your license shall also be grounds to refuse you a license, to refuse to grant you a license. Most of y'all on this class already have a license, but some of you don't. There are sometimes you have to take a license law class in a state in order to get a reciprocal license. So you don't yet have a license in that state, or there are situations where an agent has lost their license and they're applying to have it to get it back again. So again, GREC basically has full jurisdiction over granting you a license, suspending your license, sanctioning your license, or revoking your license. And likewise, grounds for denial is also grounds for imposition of any sanction permitted by this chapter. When GREC initiates an investigation to determine if a licensee is guilty of prohibited conduct and the licensee has surrendered their license or let it lapse, GREC can say, we're not going to investigate. We're just going to revoke that license. We're not going to. I have a lot of people thinking this was, hang on, I'm going to pause this for a second. Give me 1 second. All right, so continuing on with prohibited conduct. When the Real Estate Commission does initiate an investigation to determine if you're guilty of prohibited conduct and you've surrendered your license, already covered this, they can make an order revoking your license. If they've done that, that order is in effect for, becomes effective 10 days. But you can say, no, 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 I don't want my license revoked. I do want my real estate license. So you have 10 days to make a written request to have a hearing in front of GREC to have the opportunity to not have your license revoked. Now, continuing on, fair housing violations. Not only are they violations of state law and federal law, but they are also violations of license law. And your license can be sanctioned if you are found guilty of violating either state or federal fair housing laws. We're going to watch a brief video. Generally speaking, fair housing laws are they're prevalent because we do housing, of course, but they're very, very prevalent in property management and leasing. However, there are a lot of resale agents that also violate inadvertently fair housing laws for resales. So I am going to show this brief video.
Hello, fellow realtors, and welcome to your Based Buzz. I'm your host, Doreen Roberts. It's April 2014, and this year we mark the 46th anniversary of the 1968 landmark Fair Housing Act. The 1968 Fair Housing Act prohibited housing discrimination on the basis of race, color, national origin, religion, sex, familial status, or handicap. So every April, realtors celebrate Fair Housing Month to reaffirm their continuing commitment to fair and equitable treatment and a professional level of service for everyone in their search for real property. Realtors play a vital role in ensuring home ownership is accessible to everyone. The National Association of Realtors works to help create an environment where everyone can choose where they want to live and not be discriminated against as they seek to achieve the American dream of homeownership. Now, I know you would never think about blatantly violating fair housing laws, but sometimes it's the subtle things you don't think about that can cause the problems. Because the law generally prohibits stating in any notice or ad for the sale or rental of a dwelling a discriminatory preference based on any of the protected classes, we should be aware of those words or phrases that can be considered potentially a discriminating preference when preparing the remarks for MLS listings or other advertisements. And although there is no official HUD list of prohibited advertising words or phrases, there are several such lists that have been compiled by realtor associations across the country, and they're available online. Just Google prohibited HUD advertising words, and you'll get several to choose from. The thing is, if a plaintiff is successful on an FHA claim against a broker, the judgment could include not only actual damages, but punitive damages and attorney fees and costs incurred by the plaintiff. So it can be a costly error. When in doubt about whether a particular term or phrase is a violation of the law, just don't do it. Don't publish the potentially offensive remarks. So not to confuse you, but single family home is an acceptable description of a property. But family home in best area would cross the line. Cozy family room works, but perfect for the growing family puts you in dangerous territory. And close to jogging trails would be acceptable, but perfect for joggers would be a problem. Just remember to describe the property and not the potential occupants, and you'll be on the right track. As realtors, we are available to help guide consumers through all types of real estate transactions and to help everyone find a home that meets their needs. And as realtors, we are subject to the additional standard of total non-discrimination that is part of the Realtor Code of Ethics, Article 10. Violation of the code leads to disciplinary action against the realtor, in addition to the penalties under applicable laws. Next time, we're going to talk about some best practices.
All right. So let me go back to the slideshow. So the important thing about this is this really applies, well, it applies in a lot of areas, but especially in marketing and advertising. And one of the key things to remember to not violate fair housing laws in your brochures, your marketing, is to remember to describe the property and not the person that you feel the property would be ideal for living in there. Years ago, when we used to practice, I've been practicing now for, I calculated it, 29 years this year. So when I don't practice anymore, I just broker and teach. Um, uh, we used to describe the property. See yourself sitting on the veranda, sipping your coffee, watching your children play in the front yard, or imagine your daughter's wedding in the beautiful veranda. All those types of statements. Those are complete fair housing violations now. And you'll see why in just a minute. So now you have to describe the property. So for example, if a property, instead of, um, it's saying perfect for joggers, you would say within a quarter of a mile of the Silver Comet Trail or things like that. So you can't describe who you think would be great for living there, but you can describe the property. All right, so next slide. Okay, for those of you guys leaving, and I just put the link to the calendar, it does say next Tuesday, it does say license law, but we're going to switch that to dissection. Okay, Cheryl, question. I've been investing in the certified divorce specialist real estate designation. How would you describe? You can describe I don't understand your question. You can describe yourself. You can say that you're a certified divorce specialist, but you can't say this house is perfect for a divorcing couple. So, unless I'm misunderstanding your question. All right, we'll continue on.
Dana, could you hear me? Because I'm typing and I'm not getting any responses.
I can hear you now. Yes.
Okay, can you say growing family or
No.
empty nesters?
No.
No. Okay, thank
No.
you.
Yep. And I'll tell you why in a second.
Okay.
Okay. So do you work with rentals or screen applicants? Does your landlord discriminate? Um, you have to be careful. Again, these laws, what I'm talking about specific to today is the impact on your real estate license. But we have to remember these are state and federal laws as well. So your landlords, your sellers, your buyers, they are also held to fair housing laws. This equal housing opportunity symbol is not required, but it is a good idea. Now, your broker may require it, but it is not required by law. The only time it is required for marketing and advertising is if you are marketing a HUD home. A HUD home is a property where an owner got an FHA insured loan and they weren't able to make their payments. So it went into quote unquote foreclosure. Instead of that property going back to a bank, it went back to the Department of Housing and Urban Development. And so HUD does not call those homes foreclosures, they call them HUD homes. So if you do market those, this is required to be there. It is your responsibility to know the protected groups and to educate your clients. There is a HUD pamphlet. You can go to HUD.gov and get tons of information on fair housing and protected classes. So, what about this? Is sexual orientation a protected class? The answer is a mixed one. Federal law right now does not protect people against housing discrimination based on their sexual orientation. However, the District of Columbia, several cities and towns, and the following states do include sexual orientation as a protected class. And those are the states listed below. Georgia is not one of those states. What does that mean? And is this surprising? Yes, it is surprising. What this means is under the fair housing laws, there is not a specific designated group that says sexual orientation or sexual identity as an identified group. However, in 2017, there is a federal judge that ruled that sexual orientation and gender identity are protected classes. So, what this means in essence is it is a sexual orientation and gender identity is a protected class via case law, but not statutory law. Additionally, before I go to this, if you are an agent and you're writing a contract on the GAR, Georgia Association of Realtors form, in the form in and of itself, GAR does identify sexual orientation as a protected class. And if you are a realtor, meaning you belong to a local board of realtors and therefore have membership with the state board, Georgia Association, and the national board, NAR, in the Realtor Code of Ethics, you are also required to not discriminate against sexual orientation and gender identity. So even though they're not listed as statutory laws, it is in essence a case law. Now, so what are the 7 federally protected classes and how can you remember them from this time forward? If you remember the mnemonic of fresh corn, you will always remember it. So if you go down the side, you will see vertically it says fresh corn. And so how does that help you remember the classes? Well, F is familial status. So that means married, not married, children, no children. So that, Tiffany, is why you can't say quote unquote growing family. It could be perceived as discriminatory against a family or a couple that does not have oncoming children, hence growing. And it could be misperceived. Do you mean children by somebody being pregnant? Do you mean children by adoption? Do you mean children by now you have custody of your grandchildren? So, and if you don't, so that's why you can't use growing family. So F is familial status, R is religion, nothing for E, S is for sex, and that is an adjective, not a verb, and that refers to biological gender. I guess that could be argued nowadays, sexual orientation or gender identity. I am not familiar at this point in time with any specific cases regarding gender identity and this labeled group that is in the statutory law. H is handicap status or disability. This is the biggest one. This is extremely broad-ended and vague regarding what constitutes a disability. C is color, nothing for O. R is race, and N is national origin. So again, if you go down the side vertically, you get fresh corn, familial status, religion, nothing for E, sex, handicap status or disability, C for color, nothing for O, R for race, N, national origin. There is no E or O, and it's just easy to remember, equal opportunity. Correct, or can't have children. All right, moving on with prohibited conduct. Making a false statement on an application. So if you lie or omit a material fact on your application, GREC can refuse, sanction, or suspend your license. Additionally, many of you came to real estate from, this is not a first career for a lot of people. So many of you came to real estate from another career. Well, there are other careers where you had to get a license. For example, teachers, insurance salesmen, cosmetology, builders, any of those, you also had to get a license issued to you by the state. And so what this says is if your license in another occupational field, a state issued license, was sanctioned or disciplined, you need to let GREC know, and that could also impact your real estate license under this body of law. Oops. Has your real estate license been revoked? If it has, GREC can reissue a license only if 10 year only may reissue an associate broker's license only if three conditions exist. 10 years have passed, there are no criminal charges pending, and you get some affidavits from people in the community that show that you bear a good reputation for honesty, trustworthiness, integrity, and competence in order to safeguard the public interest. Next, moving on. If you've been convicted of any offense named in the following code section, you shall immediately notify GREC of the conviction. Again, this is not if you are just charged with one of these. This is if you have been convicted. So if you have been convicted of fraud, false representation, evil intent, blackmail, embezzlement, extortion, malicious destruction of property, bribery, counterfeiting, perjury, tax evasion, murder, robbery, theft, or larceny, then you need to let GREC know, and more than likely, it is going to negatively impact your license. However, if you have been convicted of one of those crimes, GREC will automatically revoke your license 60 days after that conviction, but you can request a hearing by GREC to not have your license revoked. If you are not in compliance with an order, a Georgia state order for child support, again, then that can have a negative impact on your license. It is a violation of license law under this section of prohibited conduct. If you are a borrower in default, when I taught this class during the foreclosure market, I had a lot of licensees that got a little bit frightened that they were violating license law. This is not if you are in default of a mortgage payment or any other loan. This is if you are in default of paying back a Georgia student loan, then you need to let GREC know, and it can they can refuse, sanction, or discipline your license. Moving on about requirements to transfer to another firm. Brokers, if you have changed the address of your firm, you have to let GREC know within 30 days. Agents, this is true for you as well. GREC communicates with you via the broker who currently holds your license. However, GREC's communication to us as brokers regarding our licenses can sometimes be delayed by several weeks, number one. And number two, if I hold your license today and Greg needs to communicate something to you. So they send me a letter, and then tomorrow you ask to be released and I release your license. I have no way of contacting you because you're no longer with my firm. So Greg has to have a way to get in touch with you as well. So if your address changes, or email address changes, name changes, something like that, you really need to keep Greg updated with those changes. And you can do this on Greg's website. All agents have a login with Greg. Or you can do this on the Greg change form, which I'll show you in a minute. Any licensee who is released by a broker shall not engage in the activities of a real estate licensee until you either have sent Greg in the actual change form, or Greg has received your wall certificate authorizing service as a broker, qualifying broker. So let me explain what this means. Basically, what this means is you cannot, even though you have a real estate license, you cannot practice real estate on your own. You have to practice real estate under the authority or under the liability, really, of a qualifying broker who is a qualifying broker for a firm recognized by GREC. So we have a lot of agents that have a license and even have a broker's license. And then you go to the Georgia Secretary of State and you open up your own LLC because you're going to start doing property management. And you're like, well, I have a company, I have a license, I even have a broker's license. I'm just going to start practicing property management, go start advertising and property manage. That is absolutely a violation of license law. That is practicing under without you're not under a broker if your broker doesn't allow you to practice license law. If you're going to do that, if you have a broker's license, you can do that. But your firm, regardless if you go through the state and create an LLC, that LLC has to be sanctioned by GREC. So you have to apply to GREC to have a firm, and you have to have a qualifying broker that holds the liability of all the agents within that firm. That used to be the number one issue that GREC investigated, was agents practicing property management outside of their broker with a company that was a perfectly sanctioned Georgia company, but not a GREC company. There is a form on GREC where you get this. It is called the GREC change form. And this is for all sorts of things. If you change your address, if you change your email address, if you change your name, this is also the form that is required to be signed if you ask a broker to release your license, and if you ask a broker to take on your license. So this was the quiz question where it said your original wall certificate must be held by your broker at all times. The intent of that law is still the same, but in practice, brokers don't actually have that pretty parchment license. Nowadays, we do this electronically. Brokers can go onto GREC and we can pick up your license electronically and we can release your license electronically, as long as there are no issues. If your CE is lacking or you were inactive at the time of your last renewal, we can't pick you up electronically. We do have to have this form signed and send it in to GREC, and they have to do it. The majority of brokers in their sign-on packages and their exit packages do have this form included, so that if we can't pick you up electronically, we just email this document into GREC. So again, the intent is you can't practice real estate without your license being held by a firm recognized by GREC with a qualifying broker. Quiz question. Do you have to let Greg know if you have an insurance license? No, you have to disclose that in practice. That's a little bit different issue. You only have to let Greg know if your insurance license has been sanctioned. If your activities within an insurance license, teaching license, cosmetology, if that license was sanctioned or disciplined, then you have to let Greg know that, but not if you just hold a license. That's a broker to agent issue, not a Greg issue. If you are transferring to a new broker, you may continue to act for that broker on pending sales provided. So again, this was another quiz question. In and of itself, no, you can only work for one broker at a time with a salesperson's license. If you leave a firm, you get a deal pending, you leave that firm, it hasn't closed yet. You can continue to work, and your license is now with broker number 2. You can continue to work with those customers as long as both brokers, the broker you left and the broker who now holds your license, agree in writing. If those transactions are noted in writing and the former broker accepts full responsibility for your actions, and there is a written agreement between both brokers that show compensation. There is a form GAR CO13. This is not required, but GAR has this form to help you stay in compliance with license law. It is called Agreement Between New Broker and Former Broker of Transferring Licensee. It identifies both brokers. It identifies the properties and the compensation. And this would be for the following sales, the following listings, the following brokerage agreements. And then there is a place for both brokers to sign it. A licensee may not act on behalf of any broker other than the one holding their license, except as just mentioned. A written ICA stands for Independent Contractor Agreement, is required for all licensees affiliated with a broker's firm. And in that independent contractor agreement, it must include the terms of compensation both during affiliation and on transactions begun but not completed during affiliation. So again, in this independent contractor agreement or a broker's policy manual, as long as that policy manual is referenced in the independent contractor agreement, it has to say how much compensation you are getting. And this is the main reason, one of the main reasons y'all choose a broker. Are you going with a broker because they're offering you a commission split? Are you going with a broker because you only have to pay a transaction fee? Are there certain situations where it varies? Do you have the leverage to adjust your commission based on certain circumstances, or are you required to charge a certain commission with no changes? All of this must be outlined on the independent contractor agreement. And if you are with a broker and you're on their commission, it's on a commission split. And again, you get a property under contract, it hasn't closed, you leave that broker and go with another broker. When that pending deal with your former broker closes, do they still have to pay you at that same split that they were when you were with them? I don't know. However, that has to be delineated in the independent contractor agreement. In other words, a broker can't just change how much they pay you because they're upset because you left their firm and say, I'm not paying you what I was paying you. It has to be outlined and all agreed upon when you join that firm. When a licensee requests a change form be signed, the releasing broker shall immediately sign it and forward the wall certificate. Again, as brokers, we are allowed to have, just like we have an interview process and a sign-on package, we are allowed to have an agent exit process and an agent exit package because we don't want y'all to leave. So if you're leaving us, we want to know why. What is it that looks attractive that another broker's offering that we're not? It could be something we offer that you weren't aware of. It could be something that we didn't think to offer. So we want to know what we can do to get better to serve you, our agents. So we are allowed to have exit interviews, exit packages, so forth and so on. And sometimes those do take time. However, that GREC change form that I showed you a minute ago, if there are some times when an agent is leaving a broker and it is a bit contentious and the broker, not saying that they would do it on purpose, but perhaps they're dragging their feet a little bit to send you the package or have the agent exit interview. What this license law says is if you get this form from Greg's website, you fill out your portion, you send it to your broker and say, you need to sign this to be released. This license law says if a broker is presented with that form, they shall immediately sign it and forward the wall certificate, meaning you then get that to Greg and Greg will take your license off of that former broker's roster. Transferring licensees shall not take or have in possession or use any brokerage engagement. That means a listing agreement or buyer broker agreement secured through the office unless authorized by the releasing broker. All property of the releasing broker shall be returned. So you guys are all affiliated licensees with your broker. All contracts are written in the name of the broker. All listing agreements, buyer brokerage agreements, purchase and sale agreements, are done in the name of your broker. That's what it means. So if you are transferring firms, a broker, if you have, let's say you have an active listing and you're leaving broker A and growing to broker B, and your clients want to go with you. Well, your broker is not required to terminate and release that active listing for you to take it with you to the next firm, because that listing agreement, that brokerage agreement is quote unquote the possession of the broker. However, the majority of brokers in practice do release active listings and active buyer brokerages and typically keep pending deals to close with their firm. However, license law says they don't have to. So you need to know what your broker's policy is on that. Wall certificates returned to Greg should be accompanied by a release form signed by the broker and licensee. And you have 1 month. If you leave one broker, you have 1 month to let Greg know, I'm going to stay inactive for a while, or I have found another firm that I'm going to go with. And if you don't find a firm within 30 days, you just need to let Greg know that. Now, that's if you ask a broker to release you. There are other situations where a broker can say, our business models are no longer compatible. You're not an employee. Remember, you are an independent contractor. So this relationship is not working out for the best of both of us anymore. So I'm going to release your license. So under the GREC Rule 520-01-075D, it states that if a broker is releasing a licensee for reasons other than the licensee's request and is unable for whatever reason to get your signature on a release, then the broker has to send Greg a copy of a letter that I mail to you. So I have to mail you a letter saying what that previous slide is. You now have 30 days to affiliate with another broker or let Greg know that you're going to stay inactive. And I also have to send Greg a copy of that letter that I sent to you. That's what that says. All right. If you leave a firm, you may not have any contact with any of the firm's clients that you are serving until that brokerage agreement expires or until the broker gives you written permission to do that. All right, let's move on and cover handling escrow funds. Any questions before I move on about transferring firms between one firm or another? All right. We are going to move on about requirements for handling escrow funds. So an escrow funds, an escrow account means the same thing as a trust account. And trust money and escrow money, that is money that is held by someone else on behalf of someone else. So escrow money or trust money is held typically by a broker, and nowadays by some closing attorneys if the clients choose so. It is on behalf, it is someone else's money. So for example, if I'm a broker holding trust money, I can't use that money for my own purposes. I can't use that to pay my bills. I can't use that to pay agent commissions. Somebody else has a claim on that money, typically a buyer or a seller, until something happens that was outlined in the contract, i.e. the deal closes or the deal terminates. So generally speaking, we talk about trust money is earnest money and security deposits. There's one other body, because earnest money, again, depends on if the deal closes or terminates. And security deposits, again, depend on the status of the property and the terms of the lease when a tenant vacates. So it's just being held in trust. There's one other body of money that is considered trust money. That is rent in a property management situation. If there's no property management situation and a tenant pays a landlord rent, it is not trust money. However, if the landlord has hired a property management company and the tenant makes their rent payment to the property management company, at that point in time, it is trust money because the tenant writes a check for rent payable to the property management company. The property management company then sends a portion of that to the landlord as the rent, and they keep a portion of that as fees for managing the property. So that's the only other situation where it is trust money. Okay. What a question. What happens if you are working with another agent in your firm and that person decides to change firms in the middle of a deal? Working with another agent in your same firm? Mary, I don't exactly understand your question. There's
What I
code.
was stating is if you are working, oops, sorry, I've got my phone on too. If you are working with a person in your firm on the same deal, like you were partnering with someone, and then that person decides to leave that firm,
So
what happens to
they're
that
on the other
deal?
side. So you've got a buyer, they represent, it's a designated agency situation
Yeah,
and they leave.
yeah.
Is it in your scenario, is it under contract or are you still negotiating?
It's not. I don't even have the scenario. I was just curious.
Well, it depends. If the contract is already under contract, if it's already a pending deal, more than likely the pending deal is going to stay with that firm, and um the other agent that left would have to get written permission from their broker to continue working on, to let that agent continue working with those clients.
Okay.
Um, if you're still negotiating, it just depends on the buyer brokerage. If it's an active buyer brokerage and active listing, the party that leaves, depending on which party they were working with, it's up to the broker to choose to release the active listing or active buyer.
Okay. Thank you.
You're welcome. All right. Each broker who accepts trust funds shall maintain a separate federally insured bank checking account, which shall be designated as a trust account where all funds held on behalf of another person shall be deposited. This account shall not be subject to attachment or garnishment. I will let you guys know not all banks allow an account to be a trust account. That designation for a trust account, some banks have a specific designation. Some banks let you do it that way. Some banks don't. The important thing is if that person or that firm is subject to a court order for garnishment of wages or declares bankruptcy and their assets are seized as part of the bankruptcy, the trust account must be exempt from any of that. And that's where you have to check with a bank to make sure that there is that protection for a quote unquote trust account. In 2015, there was a Georgia bill that got passed into law. So it doesn't have to be an actual checking account anymore. It can be, it doesn't have to be a federally insured bank anymore. It can be a trust or building and loan, credit union. And it doesn't have to be a checking account anymore. It's any account. It could be a money market account, a savings account, as long as that account is federally insured. GREC has 100% full jurisdiction authority into any and all trust accounts, not a broker's business account, not a broker's commission account, not an agent's business account, not an agent's broker operating account, but a trust account, because remember what I told you to remember? Safeguarding the public's interest. Well, a trust account, you are holding the public's money. So if for some reason you're a bad person, or even if you're not a bad person, but the public has an allegation that they think something's going on with their money in the trust account, GREC has the authority to access everything going on with this account. So in order to do that, brokers and agents, towards the end of the class, we talk a little bit about agent as principal, but a lot of this has to do with trust money. So if you are an agent and you have rental property and you have tenants and your tenants pay a security deposit for that rental property, number one, you are allowed to have a trust account where you can hold your your tenant's security deposit. However, just like this, those trust accounts fall under all the license laws for these, just like a broker. So your trust account, GREC has full access over that. That trust account must be registered with GREC. But guess what? The broker is the only one who can register your agent trust account with GREC. So license law allows you as an agent to have a trust account. Brokers, however, have in their policy that they may or may not allow you to do that. The majority of brokers do not allow agents to have their own trust account for their own rental properties. Why? Well, I am still responsible for that account to GREC, but I don't have access to that account. GREC does, but I mean, they don't have access to it, but you have to give them information, but I don't. So a lot of brokers don't allow agents to have trust accounts. So what do? If you're an agent and you have rental property and you are going to hold a security deposit, number one, if your broker does allow you to do it, license law says you can only hold a security deposit if you are the 100% title owner of that rental property. So if you have rental property and it's in yours and a business partner, a spouse, a child, a best friend, if two of you have, let's say you and a spouse buy rental property together, if your spouse is not a licensed real estate agent, even if your broker allows it, you cannot hold trust money. Likewise, if you create an LLC and you are not the 100% sole member of that LLC, there are other members that don't hold a real estate license. Even if your broker were to allow it, license law does not allow you to hold security deposits. So what do? You can still hold a security deposit for a rental property that you own or own with a spouse, so forth and so on, a business partner, child, best friend, whatever. But your broker has to hold that security deposit in their trust account. There's three options. That's one option. Second option is you hire a property management company and they hold the security deposit in their trust account. Or the third option is you as the licensee come off of that title of that property, and then the other business partner, spouse, child, best friend, whatever, they can hold a security deposit because they're not subject to license laws because they don't hold a license up to the point where they have 10 properties. Then there's a body of laws that govern them. So brokers and likewise agents, if this applies to you in my previous scenario, authorize GREC to examine the trust account at any time with reasonable cause and during each renewal period. In lieu of an examination, the GREC can say, just give me your, as long as I know a CPA is looking at it, give me a written report from the CPA that the trust account is maintained and required. You can have, a broker can have more than one trust account, but you have to let GREC know of each and every account. And a broker also, further on in the slides, it says, if you open up a new account, you have to let GREC know within 30 days. A broker is not entitled to any part of the trust funds paid to the broker in connection with any real estate transaction as part of the commission or fee until that transaction has either been closed or terminated. In other words, there has to be a strict paper trail for money coming in and going out of any and all trust accounts, itemized to the penny. It can come out of the trust account, again, upon termination or closing. Any licensee, okay, this is what I just talked about. You also are not entitled to any funds in that trust account until it closes. Licensees who receive trust funds on property they own must deposit those funds into a trust account maintained by a broker whom their licensees are affiliated with or in a designated trust account. That's what I just covered previously. This is part of Georgia Code, Title 43, Chapter 4020H. If a broker does approve of you holding funds in that account, the broker, I have to assure with GREC the name, all the information about that account, and you have to give me a quarterly reconciliation of that account at minimum. The licensee, there's the quarterly reconciliation. Now, again, that's under OCGA Georgia Code. Now, GREC also has rules regarding trust money. You can have multiple trust accounts. You have to notify GREC within a month of opening each account. This was the quiz question. Licensees shall place all cash, checks, or other items of value received into the custody of their broker holding their license as soon after receipt as is practically possible. Again, your broker may have a stricter time limit, i.e. 3 business days, but license law is a little bit more open-ended. When acting as principal, again, principal is buyer, seller, landlord, tenant. When acting as principal in the sale of interest in real estate owned by the licensee, the same applies. In other words, you're putting your own house up for sale and the buyer wants to give you earnest money. Well, that earnest money is treated the same way it is treated on any transaction. It's not different just because you are the seller. All cash, checks, or other items of value received into the custody of your broker holding your license as soon after receipt as is practically possible. Now, nowadays, we know, additionally, in our contracts, it is not only just a broker that holds these trust accounts, it is also the closing attorney if the buyer and the seller negotiate for the closing attorney to be the holder of the trust funds, and that closing attorney agrees in writing to do that. Okay, so that license law says when you have to get the trust funds to the holder. Now, what about as a broker? When do I have to deposit those funds? Well, license law says as a broker, I have to promptly deposit those funds into a trust account or make appropriate arrangements for safekeeping of other items of value. Again, promptly is relatively vague. Your contracts have more specifics guiding when, as a broker, I am required to make that deposit. For example, in the GAR contract, it says 5 banking days, and in the RE forms contract, it says 3 banking days. If a broker's trust account bears interest, the broker shall obtain written agreement of the parties indicating to whom the broker shall pay the interest prior to making that deposit. What does that mean? That means so what does this mean for you as an agent? This means for you as an agent, whomever in a contract you designate as the holder, whether it be one of the brokers or a closing attorney, you need to first of all know, are there trust accounts? Do they bear interest? If so, who gets the interest on that money? So here's the good news. The good news is if you are an agent and you are signing, your clients are going under contract using the GAR purchase and sale agreement or the RE forms purchase and sale agreement, guess what? They have you covered to not violate license law. All of this information is pre-printed in those contracts. And so when your buyers and sellers sign the contracts, they are giving their consent, their written agreement regarding the holder of the trust account keeping the interest if it is an interest-bearing account. If you are not writing on a GAR or RE forms contract, you are in violation of license law if the holder of the earnest money, if the holder of that trust account bears interest and that is not disclosed. Just some things to keep in mind. You can keep your own money in there only to avoid any bank fees or cover any bounce checks, because you can't pay a bank fee from somebody else's money. And only checks payable to the broker may be used to withdraw money designated as the broker's funds. In other words, again, there must be a strict paper trail of money coming in and money going out of a trust account. And again, Greg, you have to keep good accounting. You have to follow good accounting guidelines for this trust account so that Greg can read it and make sense of the money. And it can be anything. It can be manual. It can be electronic. It has to be readily accessible and available and understandable to a Greg investigator. If a broker disperses funds from their trust account contrary to the terms of a contract, they will be considered by Greg to be incompetent, and their personal license and the firm's license can be disciplined, sanctioned, or revoked. I have fulfilled my duties according to license law. Once money's in my trust account, when I take it out, I have properly fulfilled my duties as long as there was an offer that was never accepted. There was withdrawal of an offer not yet accepted at the closing of a transaction, or upon the receiving of a written agreement signed by all parties having an interest in the funds, separate from the contract that directed the broker to hold the funds. Okay, I'm going to stop here for a second because this impacts your practice. So the contract that directs the broker to hold the funds, that's the purchase I'm going to just use purchase and sale. That's the purchase and sale agreement that says the holder of the earnest money is ABC broker. Now, also in that contract, there's all sorts of contingencies. There's a due diligence period, a financing contingency, an appraisal contingency, so forth and so on. And the buyer and the seller agree. Let's just use the example of a due diligence period. Let's say there's a contract and the seller agrees to give a buyer 10 days due diligence. That means the buyer has 10 days to to tell the seller, I'm going to go through with the contract or I'm going to terminate. If the buyer chooses to terminate, they can terminate for any or no reason. They send notice to the seller before the end of that 10th day, and they do get their earnest money back. All right. So the contract not only designates directs the broker to hold the earnest money, but it also gives all sorts of information about who gets that earnest money back upon closing and upon termination. But this part of license law says, as a broker, I can't release that earnest money without a written agreement signed by all parties, and that agreement is separate from the contract that told me to hold it. That's why I need a signed release agreement, and GAR has the termination and release on one form. The RE forms package has the termination on one form and the release on another form. So in my example, 10-day due diligence period, buyer terminates on day 5. You send the seller a termination and release. For whatever reason, the seller does not sign and asking for the earnest money back under due diligence. For whatever reason, the seller does not sign the agreement to release the earnest money. I cannot just automatically give the earnest money back to the buyer because I do not have written agreement on a document separate that where they agreed to allow me to do that. So what do? Well, I can either say, this is too much money or it's too complicated. I'm going to interplead it and let a judge decide. There's court costs associated for doing that, and I get to take those out of the earnest money. Or if I get a court order, I have to comply with the court order. Or upon a reasonable interpretation of the contract. We refer to this as the 10-day letter. I'll tell you why in just a second. So back to my example, 10-day due diligence period, buyer terminates on day 5, send the seller a TNR. The seller doesn't sign the release portion agreeing to release it. License law says I can't just give it back to the buyer. Your buyer's like, you told me my earnest money was protected under this due diligence thing. Well, then it is, they get it back, but they don't get it back immediately in my example, because then I get to reasonably interpret the contract. So I go back to the contract and I see seller agreed to give the buyer a 10-day due diligence period. Buyer sent notice of termination to the seller at the email address listed on the contract on day 5. Yes, they are entitled to their earnest money back. So I would interpret the contract that way. And then the contract says I have to send my notice to both buyer and seller of who I'm giving the earnest money back to and why. However, I have to wait for the party not getting the earnest money back. I have to wait 10 days for them to object and for them to show me in the contract or in an amendment. There could be an amendment I'm missing, why my decision is wrong. And so I have to give them 10 days to make that decision, to make an objection. And then if their objection is not contractually based, then on the beginning of day 11, I can disperse the earnest money. Additionally, I do not have to disperse the earnest money until I'm sure it has cleared the bank. So many brokers have a policy about releasing trust funds. This is an issue. You guys, point of practice. When you are working with buyers or tenants, but especially buyers, they really should be dealing with earnest money in the form of a bank check, a wire, or potentially a money order, not necessarily a personal check or even a business check, because those take a lot longer to clear the bank. And a bank check or a wire typically clears within 24 to 48 banking hours. So let's say, and many brokers have a policy like 10 banking days. So if you're a buyer, so back to an example, your buyer goes under contract with a seller, 10 days due diligence period. They write a check for $4,000 based on a personal check to the broker holding the earnest money. They terminate on day 5. Let's say the seller agrees, they say, fine, they sign the release portion, and now your buyer finds property number 2 that they want to write an offer on, And that seller number 2 is going to want earnest money. Well, if it's a personal check, license law says I don't have to give them their check back until I've got assurance it's cleared the bank. I could have a policy that I'm going to hold that earnest money check written on a personal check for 10 banking days. We're now day 7 after the buyer has deposited that earnest money check with me. They found another property. They're and you're gonna and that seller's gonna want earnest money, and the buyer's gonna say, great, you already have earnest money, just use what your broker's holding. Guess what? I can't do that. That earnest money per my policy is still on hold. I cannot act on that money for the second contract until that policy has cleared. So you as the agent have to go back to your buyer and say, I need another check for $4,000. And they're going to hit the roof. They're going to say, what are you doing with my money? Right? So, point of practice. Number 1, deal with certified funds, wire, or money order. Also, most holders have a policy. If it's over $5,000, it must be in certified funds. And if it's over $10,000, it must be in a wire. Second thing, you want to check, if it is going to be a personal check, you want to know the policies of the holder regarding their time frames for holding personal checks, or some holders look at a business check as a personal check. All right. And again, this has to do back with the 10-day letter. Again, if there's a 10-day letter and I disperse the money, I have to let the parties know who I dispersed it to. This information is in your contracts. So this is the verbiage in the current Georgia Association of Realtors contract, GAR F201. It is paragraph B7. So you can point all of this out to your buyers and your sellers. This paragraph B is where it talks about the disbursement of the earnest money, including everything we've just talked about. This is all in there due to license law. Here's where it says the 10 days. That's why we call it the 10-day letter. Here's where it talks about an interpleader action. And here's where the buyers and sellers agree to hold the holder harmless for their decision based on the disbursement. I want you guys to know, if you go binding on a GAR contract and the buyer defaults and the holder disperses the earnest money to the seller as liquidated damages, look at this section. The above referenced check shall constitute liquidated damages in full settlement claims against buyer and seller and brokers. Holder may require the seller to sign a W-9 before issuing a check to the seller for liquidated damages of $600 or more. That means that seller is going to get a 1099 at the end of the year and have to pay taxes on that money. Just know this is a provision of the GAR purchase and sale agreement. And if you go binding under the RE forms, this information about the disbursement of earnest money is handled under RE1, which is the standard terms document, paragraph 3.4. All right. See, I've got a question. Not perform due to title issues. Okay, I represented a buyer and seller who could not perform or close due to title issues. The seller refused to sign the disbursement. Seller and attorney holding the earnest money were served the 10-day letter, and attorney still refused to disperse the earnest money. Well, so this brings up an issue with yeah, that it seems to me that I don't know all the terms of the contract, but per the question as asked, it seems like the seller, generally speaking, may have defaulted by not being able to come to closing with good and marketable title. However, I don't know if the buyer sent notice. There's all other things in the contract to comply with that. But relative to this discussion, just one thing to consider when talking to your buyers and sellers about closing attorneys holding earnest money: they can't do anything illegal, but if the closing attorney doesn't hold a real estate license, Greg has no governing authority over a closing attorney. All brokers, I have a real estate license. All your brokers hold real estate licenses. So if I do something contrary to license law regarding earnest money, my personal license can be sanctioned or revoked or suspended, and my firm. But not a closing attorney. That would have to be handled civilly because Greg has no authority over a closing attorney's license. When a closing attorney signs the GAR form agreeing to fulfill the responsibilities of holder, that's one thing, but Greg has no statewide regulatory jurisdiction over closing attorneys with respect to these license law issues. And again, this is just a repetition of everything we've covered. It's just in Greg rules regarding how the handling of escrow money. And it's the same thing that we have been talking about. All refunds of trust money, again, must be made by check or credited at the closing of a transaction. Again, a paper trail. Again, zero balance line, dollar in, dollar out must be accounted for. And I mentioned this a little bit earlier, but if you hold trust money, if a broker holds trust money, if a firm holds trust money, and any of those entities declare bankruptcy, you must let Greg know in writing because they must take procedures to protect those trust accounts. And I already mentioned this earlier. If you manage rental property in order to hold trust, in order to have a trust account, if your broker allows it, you must be 100% the sole owner on title. If the title is held by an LLC, you must be the sole member of that LLC. All right, let's take a break before we knock out the rest. So I am going to. So continuing on, we are going to continue on with unfair trade practices prohibited in Georgia. Now, a lot of these, as I mentioned at the beginning of class, are repetitive, are issues that have already been addressed under effects of prohibited conduct on your license. So, but now they're under the section of law covered under unfair trade practices. So if it's something we've already talked about in depth, I'm going to go a little bit quicker. And again, for the purposes of these next few slides, sale is the same thing as lease, option, exchange, or transaction. So all of these laws apply to real estate transactions, regardless of the specific type of transaction that it is. Just like owner, landlord, buyer, tenant will be used interchangeably for party or principal. So the first one, because of the way to read these slides is, it is an unfair trade practice for you if you refuse to sell after making of a bona fide offer, refuse to negotiate for the sale, or otherwise make unavailable or deny real estate to any person because of race, color, religion, sex, disability, familial status, or national origin. What do these sound like? They sound like the protected groups from fair housing. So we've had a pretty good in-depth discussion on fair housing. So basically, these groups are protected not only under fair housing laws and effects of prohibited conduct on your license, but also under the unfair trade practices law. Additionally, you cannot discriminate against any person because of these groups. You can't tell them different terms or conditions or privileges or facilities. Like you can't tell one potential buyer this sale price and another potential buyer a different sale price. Additionally, based on these protected groups, you cannot make, print, publish, or cause to be made, printed, or published any statement, notice, or advertisement with respect to the sale of real estate that indicates a preference, limitation, or discrimination, or an intention to make any such preference, limitation, or discrimination based on one of those groups. And you can't represent to any person that real estate is available or is not available based on any of these protected groups. You may not represent explicitly or implicitly that a change has happened or will happen in a block or neighborhood or discouraged. In other words, you can't say, "Ooh, you don't want to live there. That neighborhood's changing because of one of these issues." Additionally, it is an unfair trade practice to intentionally advertise material which is misleading or inaccurate or in any way misrepresents any property, terms, values, policies, or services of the business conducted, and failing to account for and remit any money coming into a licensee's possession which belongs to others. What is that? Again, that's earnest money, security deposits. That's any kind of trust money. It's also an unfair trade practice to commingle money or property of a principal with yours. Sometimes agents accidentally are trying to be nice and they violate license law. In other words, there are some agents that deal with active military personnel, and they are overseas and they have found a property they want to write an offer on. But it'd be challenging getting earnest money or getting a bank check to the agent to deposit with the holder. So the agent says, "No problem, Venmo me the money, send me the money via Cash App or PayPal, and I'll go get the bank check or I'll write an earnest money check." No, 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 no. You might be trying to facilitate the process and be nice, but you are absolutely violating. That is an absolute unfair trade practice. That is commingling your money with their money. Also, it's an unfair trade practice to fail to disclose in writing to the principal. Again, principal is buyer, seller, landlord, tenant. Any of the following: receipt of a fee, rebate, or other thing of value on expenditures made on behalf of the principal for which the principal is reimbursing the licensee. Payment to another broker of a commission fee or other thing of value for the referral of the principal for brokerage or relocation services, or receipt of anything of value for the referral of any service or product in a real estate transaction to a principal. So this has to do with most of your brokerages have what they call an affiliated business disclosure. Basically, certain vendors will pay a brokerage an amount of money to be on their vendor list to get exposure to the agents so that the agents are aware of the services and products they provide that could help their clients and customers in a real estate transaction. Because there is money exchanging hands from the vendor to the real estate firm, you have to disclose that to the buyers and sellers that there isn't we're receiving there's a different business relationship going on. And so that's what the affiliated business disclosure is. So many of y'all have seen this. And again, many companies have their own. For example, these are fair housing words. I have an example here to show you guys. And this is just a sample one where it just discloses either generically that some of the vendors that agents suggest or offer as a ministerial act are that there is an outside business relationship. Now, just so y'all know, your own clients and customers need to sign that, but oh man, it does not need to be part of a contract because every brokerage firm has a different business relationship with various vendors. All right, I lost my place in the slide, so let me find the slide really quickly, and we will continue on. All right. It is also an unfair trade practice to represent or attempt to represent a real estate broker other than the one holding their license without the express knowledge and consent of the other one. Again, we've talked about that under the prohibited conduct on your license. Licensees accepting a commission from anyone other than their broker holding their license without the consent of that broker, and acting as dual capacity as agent and undisclosed principal. In other words, you are the agent and you are also going to buy the property or you are selling a property. You must disclose that you hold a license, that you are the buyer or the seller, and landlord or tenant, and that you do hold a license in the state of Georgia. It is also an unfair trade practice to put a sign on a property offering it for sale or rent without the written consent of the owner or the owner's authorized agent, and to remove such sign within 10 days after the expiration of the listing or after it has been sold. It is an unfair trade practice to offer real estate for sale or lease without the consent of the owner or the owner's authorized agent on terms other than those authorized by the owner or the owner's authorized agent. And it is an unfair trade practice to induce any party to an existing contract or brokerage agreement to break such contract or brokerage agreement for the purpose of substituting another contract or brokerage agreement with another principal. In other words, let's say you have a listing, and let's say you're at the listing doing something, putting a sign in the yard or doing something, and some potential buyers drive by and they're looking for a house for sale. And they stop and you have a conversation in the yard, and it's exactly the house they're looking for. And you're the listing agent and you say, well, are you working with an agent? And they say, well, yes, we are. We're working with a great agent, but we just happened to be driving by and saw you out here. Can we see the house? And you say, well, sure, I'll show you the house. You have knowledge they have an agent, but you're there. You want to go ahead and show them the house. And then they like the house. And you tell them, look, if you fire your other agent, I can get you a better deal because I have some more leverage. That is an absolute unfair trade practice and a license law violation. That's what it means, substituting one contract or brokerage agreement with one principal for another. It is also an unfair trade practice to negotiate a sale directly with the party if the licensee knows that such party has a written outstanding contract in connection with such property granting an exclusive agency or an exclusive right to sell to another broker. We call that, in the past, we used to call that crossing a sign. You can't talk to the other party's client. Now, I will let you know too that even if you know the other party is working with their public person as a customer, that still does not give you the authority to bypass the agent and talk to the other party. So if you're a listing agent, you have a client relationship with the seller, and the buyer is working with a broker, and you get an offer or you're under contract, and on the contract, it does say that they are working with them as a customer. That's the nature of the relationship. You still have to go through the agent. It is not free for all just to talk to that public person. Additionally, this falls under the unfair trade practice. Basically, the term appraisal is a protected term, and you must hold an appraiser's license. So what this says is indicating that an opinion given to a potential party regarding a property price is an appraisal unless you hold that license. You can say a market evaluation, market opinion, so forth and so on. It's an unfair trade practice to perform or attempting to perform any of the acts of a licensee on a property located in another state if you don't have a license in that state. A lot of agents get confused when they hear the term license reciprocity. For example, Florida has license reciprocity with Georgia. That does not mean that if you have a Georgia license, you can practice real estate in Florida. All that means is if you are going to get a real estate license in Florida, you don't have to start at pre-license school. You basically go take their license law test, and then you can go sit for their state exam. So license reciprocity just means there is a shortened methodology of getting a license in that state by virtue of having a license in Georgia. Okay, this was the quiz question that tripped a lot of you guys up. When can a broker pay a commission for performing real estate services to someone who is not licensed? And the first one is a sad one. A broker can pay a commission to an estate or to heirs. So if there was an agent and they got a deal under contract and then they passed away, the commission that agent earned while they were alive can still be paid to their estate or to their heirs. But that obviously that estate or those heirs don't hold a license. The next one is there are some foreign countries where they don't hold a real estate license. Nevertheless, they were a party to the deal, acting in the same capacity as an agent or a broker. And so a broker can pay a real estate commission to the citizen of another country acting as a referral agent. And this is the one y'all weren't thinking about. Many of y'all, especially nowadays at tax time, there are many CE classes on and classes and all sorts of information about should you incorporate as an LLC or some type of corporation for tax purposes. And if you do that, you have your firm, the broker holding your license, the commissions that you earn as a licensed individual, those get paid to your LLC, again, typically for tax reasons, or sometimes there's other legal reasons. Well, a broker can pay your LLC. The LLC in and of itself doesn't hold a Georgia real estate license. You as an individual do. So what the law says is that a broker can pay an unlicensed firm, i.e. an LLC, as long as the individual licensee affiliated with the brokerage firm owns more than 20% interest and they've earned the commission on behalf of the brokerage and that firm doesn't do real estate. So again, that's all just a lot of fancy words to mean you have created an LLC or some type of corporation with the state of Georgia where you are going to run your operating account for your business, again, for tax purposes or legal purposes, but that LLC doesn't practice real estate. All right, it is an unfair trade practice to fail to include a fixed date of expiration in any written listing agreement and to fail to leave a copy with the principal. Also, failure to deliver within a reasonable time a completed copy of any contract or offer to the purchaser and to the seller. Failure by the broker to deliver to the seller in every transaction at the time of the transaction is closed a complete and detailed closing statement showing all of the receipts and disbursements handled by such broker for the seller. What is that? This is the closing settlement statement. So if you guys are at closing, you need to make sure that the buyer and the seller get a copy of the closing statement. This is really important if your buyers and sellers are not necessarily at closing, or if you are not at closing. You need to make sure so as to not violate license law that they do get a copy of the closing settlement statement because that itemizes all the money. Same thing for the buyer. And you must keep true copies in your files. It's also an unfair trade practice to make any substantial misrepresentations, to act for more than one party in a transaction without the express written consent of the other party. Again, dual agency, this is dual agency. It is legal in and of itself as long as you get written consent of all the parties. They all must agree. Now, your broker may have a policy prohibiting it, but it's not illegal as long as it is disclosed and they agree in writing, if your broker allows it. Here's more about earnest money. Unfair trade practice. Failure of a licensee to place as soon after receipt as is practically possible in the custody of their broker any funds entrusted to the licensee by any person dealing with the licensee as a representative of that licensed broker. Unfair trade practice, having demonstrated incompetency to act as a real estate licensee in such manner as to safeguard the interests of the public, or having demonstrated any other conduct which constitutes dishonest dealing. Also, obtaining a brokerage agreement or contract from a party while knowing or having reason to believe that another broker has an exclusive agreement with such party, unless the licensee has written permission from the broker having the first exclusive brokerage agreement. This one is really tricky. Basically, what does this mean? This means if you're an agent, and it typically happens, or more predominantly happens with buyers. A public buyer comes up to you and says, "Hey, I heard you were great. I'm looking to buy a house. Can you help me?" And you say, "Well, are you working with another agent?" And they say, for example, "Well, I was, but I fired my other agent." Okay. What does that mean? Fired my other agent. Did they do it in writing? Was there a written termination of a brokerage agreement? Was it a unilateral termination of a brokerage agreement? Was it a mutual termination of a brokerage agreement? Were there any early termination fees in that brokerage agreement? Did they just stop talking to that buyer's agent? You have no idea what that means. But the fact that they mention another agent gives you reason to believe that another broker may have an exclusive agreement with them. You say, "Well, did you sign anything with them?" "Well, I don't remember," because they just want you to help them and see the house. This is what this situation covers. You, as agent number 2, you need to contact that other agent, because this gives you reason to believe they may still be tied up in a brokerage agreement with another broker. And that means they may still owe a commission to another broker, depending on if they purchase a house. So you have to determine this based on license law and the issues above. The agent should tell the buyer that he or she needs to talk with the current broker to ensure the relationship has been terminated in writing, and only then can the buyer work with us, just so the buyer is not obligated financially to the other broker. Here is a point of practice. If you have reason to believe that a buyer or seller may have an outstanding brokerage agreement with another broker, you need to confirm with that person that they have been. Now, for a seller, expiration, definitely an expiration, but a withdrawal from FMLS should suffice, but not necessarily, because there are some agents where the strategy is that they would withdraw a listing from a listing service temporarily, only to relist it to get a new listing number and regenerate some excitement on the internet. So a withdrawal from FMLS and Georgia MLS, or any MLS, does not always indicate a termination of a brokerage agreement. But for a buyer, if you don't get a copy of the termination, then point of practice, and run this by your own broker, is you would send an email to the former broker that says, "Such and such has approached me for representation regarding real estate transactions. I have reason to believe that this buyer has terminated the brokerage agreement with your firm. In compliance with license law, blah, 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 please confirm this termination. If I do not hear back from you within 24 hours, I will accept this non-response as confirmation of the termination of the brokerage agreement with your firm. If the buyer doesn't give you the name of their previous agent, then I suggest you get the buyer to sign, buyer, affirm that I have no written obligation to work with any broker for my real estate needs. All parties agree to indemnify and hold agent and brokerage harmless from and against all claims, injuries, suits, and damages arising out of these parties' answers to the above choices. And again, always check with your own broker. But that's to help keep you in compliance with this unfair trade practice. And then you need to keep copies of all your records for 3 years. Also, being a party to any falsification of any portion of a contract or other document involved in a real estate transaction is an unfair trade practice. And failure to get written agreement of the parties. Again, we talked about this regarding any interest earned on a trust account prior to the holder depositing those funds. Again, it is a trade practice if you have an agency relationship with your buyer or your seller and you fail to disclose that in a contract. So again, on the GAR and the RE forms, there are fill in the blanks for this agency relationship. If you are an agent and you're working on another contract, let's say new construction, HUD contract, attorney written contract, they don't necessarily have a fill in the blank or a disclosure of the agency relationship. So if you are, for example, working with a buyer who signed a buyer brokerage agreement with your broker and you're helping them write new construction, you need to make sure to add a special stipulation into the contract disclosing the agency relationship you have. It is also an unfair trade practice to induce any person to alter, modify, or change another licensee's fees or commissions for real estate brokerage services without that licensee's prior written consent, and failing to obtain a person's written authorization to refer that person for brokerage services, and failure to disclose compensation. Again, everybody answered this correctly with the quiz, but I'm not sure that everyone is using the proper forms. So if you get someone that says, hey, I'm going to move to Maryville, Tennessee. Can you help me find an agent there to help me buy a house? And you say, sure, I'd love to. So you find a great agent in Maryville, Tennessee, and you're going to refer me as a buyer to them. And you use this broker to broker referral agreement to go through and negotiate when the buyer buys a house in Maryville, Tennessee, and that broker gets paid. They're going to send your broker a referral fee and your broker is going to pay you. You're all used to doing that and securing payment for the referral fee. However, license law says you have to get the public person, the buyer that asked you for the referral. In my example, it could be for a seller too. You have to get their written permission. So GAR has this form, referral authorization, where they sign it, acknowledging basically that you're making money off of sharing their contact information. And then these are the forms if you use the RE forms, the broker to broker referral and the prospect's acknowledgement and consent to referral. If I have any property managers on here, send me an email. I have a whole separate handout with additional rules and laws that apply to property management and community association management. All right, we're going to move on to broker relationships and handling transactions. Again, this isn't how much you like or dislike your broker. These are buyers and sellers signing a document, a brokerage agreement that would make them a client of your broker. Each exclusive brokerage agreement must have all the terms set forth and have an expiration date. And again, they get a copy. GREC prohibits a net brokerage engagement. What does that mean? That means you have to put all the money in a brokerage agreement, what the commission is, and especially nowadays, just so you know, this is March 2024, and our school, the Real Estate Academy of America, we are going to teach a class. There are a lot of classes coming out about the NAR proposed settlement agreement and commissions. We are going to teach a class where we've sent it in. We're waiting to get approved by GREC, which should be shortly, on the NAR settlement and real estate, the impact for real estate agents in Georgia. So stay tuned for that. We should be teaching those as soon as we get permission, the course approved from GREC. And this is just changes every day. But back to this issue. What is a net brokerage engagement? A net brokerage engagement is when a seller says, hey, I just want to net a certain amount of money. Whatever you can make over that is good for you. That's definitely a license law violation. And that is also included. That is also going to be a violation of this new NAR settlement when it goes through. Disclosure of brokers' relationships. No licensee shall buy interest in a property listed with the licensee or the firm on which the licensee or the firm has been requested to act as broker unless you clearly disclose your position to buyer and seller and insert a clause that says basically that you are licensed. In other words, GREC again is looking out for the public, and you have or should have knowledge and information above and beyond a public person who does not hold a real estate license regarding how real estate contracts work, how real estate transactions work, all the ins and outs of all the hard work that you do to get deals to close. So you have to disclose to the public that, yes, I'm the buyer or the seller, and I hold a real estate license. Sorry, I skipped one. A licensee shall provide written disclosure revealing the party for whom the firm is acting and from whom the firm will receive valuable consideration for its efforts as an agent. If the licensee's firm is not acting as an agent for either party, in other words, you're working with for sale by owner and the buyer is a customer, so you're a transaction broker for both, then you have to make a written disclosure revealing which side is compensating the firm for your efforts in the transaction. And this written disclosure is required, must be made in a timely manner before any offer to the property. So again, that just has to be disclosed. Who is paying the brokerage fees for the good and valuable services that the broker/agent is providing for this transaction? Real estate licensees shall not pay a fee or commission to a licensee representing another party except with full knowledge and written consent of all parties. All right, under handling transactions, you must present all offers, period, end of story. It doesn't matter if you have a listing under contract and you get another offer, you must present that offer to the buyer. Additionally, if you got an offer, let's say this says if you've received an offer to purchase a property from someone you do not represent as a client or customer, you still have a responsibility to deliver that offer. What does this mean? This means you had a listing, the listing expired, and 2 days later, you get an offer from a buyer or another agent. It is no longer your listing. You still, per GREC Rule 521.10.1, must deliver that offer to the new listing agent representing that seller. A licensee who obtains an offer may negotiate directly with the owner only if they have, if they know the seller has a written agreement where they have permission to negotiate directly with the seller. A licensee preparing or signing a brokerage agreement shall include the license number of each firm and the license number of each licensee. Couple of things to keep in mind here. Point of practice. Again, there's fill in the blanks for this on the GAR forms and the RE forms. If you're an agent helping a buyer or a seller with new construction contract, an attorney written contract, a HUD contract, so forth and so on, if there is not a fill in the blank for the license number of your firm and your license number, you need to add it in there to stay in compliance with license law. The other point of practice regarding this one, if you are an agent on a team, let's say you are a buyer's agent on a team and you help a buyer buy a property on any contract, but even on the GAR contract, the fill in the blank, it has the fill in the blank for your firm's license number, but this says shall include license number of the firm and of each licensee participating in the transaction. Well, obviously you think of the buyer side and the seller side, but this also means if you're a buyer's agent on a team and you are working representing that team, then on the fill in the blank for the license number, you need to put your license number and you need to put that team leader's license number. And I don't mean team leader is a firm used by some of our brokerages here in Georgia and throughout the country. It doesn't mean the broker or the assistant broker. It means if you are on an actual team and one agent is the head of the team and you're a buyer's agent working for that team, you have to put that head agent's license number as well as your own on the contract. And again, copies. Basically, these next few slides, anything your public people sign, they absolutely get a copy of. And as mentioned earlier, please make sure your brokers and your closing attorneys and lenders also get copies of everything. Especially there are some closing attorneys where agents forget to send them an amendment and it changes the terms of, there might have been an amendment to change the price or a concession that happened after an inspection. And if your closing attorney doesn't get this, it could cause delays because the preliminary HUD statement or closing statement isn't correct, or the lender didn't get a copy and they have to approve it. Again, any offer accepted and signed, everybody gets a copy. Copies of everything must be maintained in the broker's files for 3 years. I suggest your files as well. And I suggest you keep them for approximately 5 years. GREC is running about 18 months behind in their investigations. In other words, investigations they're doing now are from issues that were brought up a year and a half ago. So if you dumped your files from 3 years ago, 3 years, and an investigation comes up at the end of that time frame, you still could be held. If you don't have documentation outlining what happened, it could be an issue for you. And brokers must keep copies of all documents in that, as well as any brokers identified in a contract, especially if they participate in any negotiations, in a brokerage agreement or a transaction, or where they were named as the holder of earnest money. Copies of documents and records required to be maintained, they can be kept in any form. So you don't have to keep the paper document. They can be scans, they can be in electronic, so forth and so on. But you have to be able to produce them if GREC requests them, and they have to be in a way that GREC can read them. No licensee shall falsify or be a party to the falsification of a document involved in a real estate transaction or knowingly represent either verbally or in writing to a principal or any interested third party anything other than the actual price, anything other than the true and actual down payment, the amount of earnest money or security deposit, the form of that money, a payment a payment of trust funds in cash when in fact it was made some other way, or an artifice, contrivance, or machination with the intent to deceive. So basically that is anything that is wily or trickery or guile or craftiness. In other words, you can't intentionally mislead or deceive any of the parties in the transaction regarding any of that information. All of that constitutes misrepresentation. Continuing on with handling transactions. This is about the disclosure of commissions, fees, and rebates. The disclosure of payments to another broker must be made in writing. They can be made in advance based upon pre-established terms set forth in a brokerage agreement, management agreement, or other written agreement. In a transaction where a licensee refers a principal to another broker for brokerage or relocation services, and the broker to whom the principal is referred knows the referring licensee's expectation is to receive a commission, fee, or other thing of value, that you must disclose this. The payment to the referring licensee shall be disclosed in writing to the principal by the broker to whom the referral was made no later than at closing. This disclosure is required, shall be in addition to any requirements of federal law pertaining to the payment or receipt of anything of value per our RESPA laws. For the purpose of this law, the term licensee's principal, again, is a client or a customer. It is the public person working with the firm, regardless if they've signed a brokerage agreement or not. A licensee may rebate to a principal any part of a commission, fee, or other compensation received by the licensee related to the sale of real estate. So you can rebate your commission as long as it's disclosed on the closing statement. So no commission rebates after closing, and the rebate doesn't mislead anybody else in the transaction, the other agent, the other party, lender, closing attorney, or any government agency involved regarding the source of the funds to complete the transaction or the financial resources or obligations. In other words, if you're going to rebate your commission back to the buyer and they're going to use it for their down payment, you have to let the lender know that, and everybody know, that portion, and get the lender's permission, that portion they're using for their down payment is a commission rebate. It's not their own money that they have. So that's what all that means. Notwithstanding anything to the contrary, no disclosure is required for gifts, products, services, or other things of value given to a principal by a licensee, as long as they're not contingent upon the purchase and sale. In other words, you can give a closing gift. That doesn't have to be disclosed. But what you can't do is in advance, you can't say, hey, if you work with me, if you let me be your agent, I'll give you a gift card for X amount, or I'll buy you such and such appliance, or I'll make a donation to a charity of your choice, as long as the deal closes. What's that? That's a referral fee, and only brokers can pay brokers referral fees. So a closing gift you can give, but you can't put strings attached to the closing gift. And I'm saying closing gift, so obviously it's after a closing, but you can't make the promise beforehand of something of value contingent upon a deal closing. Management responsibilities for real estate firms. I am going to briefly go through this. Basically, with a salesperson's license, you can only have your license with one firm at a time. If you have a broker's license, you can have a broker's license with more than one firm. You can be an associate broker with one firm and a qualifying broker for more than one firm. So how does this work? Well, many firms allow their agents to practice resales, residential resales, or new construction, but do not allow their agents to practice property management. Well, you have a broker's license and you want to practice property management. Well, you can open up your own firm with GREC and be the qualifying broker for that firm. So you could be an associate broker with the resale firm and do business with them for all the resales, and be a qualifying broker for your own property management company. And you can split your license that way. If you're going to do that, again, the property management company has to be a firm recognized by GREC with the qualifying broker acknowledged by GREC. If you're going to do that, both brokers of both firms have to agree in writing. So the broker of the firm where you're doing your resale residential business, they have to give written permission that you can also be broker of another company. And the broker of the other company, you have to have, that all has to be in writing. Now, this has to do with an assistant. If you have an assistant that is licensed, they can do anything a licensed person can do because they're held to the same body of laws. If you have an assistant who is not licensed, they are very limited in what they can do. These next slides talk about what your unlicensed assistant may and may not do. Additionally, you must have a contract with any assistant, whether they're licensed or unlicensed, and your broker must be a party to that contract, because you as the agent, you are doing business name in the name of the broker. So anybody that you hire that's helping you doing business in your name, they are also doing business in my name. So I have to be a party to that contract and approve. Unless the support personnel holds an active, okay, we talked about that. If you're an unlicensed assistant, can only do ministerial acts, which are those acts that do not require the discretion or the exercise of the licensee's own judgment. Also, while I'm talking about this, there are a lot of agents that will use a virtual assistant or a virtual transaction management company or a transaction to close company. You guys, this all falls into place for that too. You really should have agreements in place with them that your broker signs off on. An individual, so for it, and if you are one of these people and you're doing a side job, or this is your job as a transaction coordinator or a virtual assistant, you can do it for agents with more than one firm. An individual licensed with one firm may work as support personnel for a different firm or for a licensee of a different firm with the written consent of the broker of each firm. And an inactive licensee can also do this. Any real estate brokerage firm that allows an affiliated licensee to use an assistant support personnel must, again, this is what I already said, enter into a written agreement with the affiliated licensee authorizing the use of the assistant, delineating those duties that they may perform, and approving of any compensation arrangements. Enter into a written agreement with the support personnel assisting its affiliated licensee, again, specifying the duties that they may undertake, and assure that everybody has written into a written agreement and how it's going to be compensated. If you don't want to come up with your own agreement, GAR does have a form. It's GAR form C007. This is what it looks like. You can use this, or you can use this as a sample. That is an agreement for a licensee's use of a real estate assistant. And again, it does have a place for the broker to sign, the licensee to sign, and the assistant to sign. If the assistant's license is being held by another broker, their broker must also sign it as well. All right. In order, and then these are the things that your assistant may or may not do. This is what an unlicensed assistant may do. And I'm going to run through these. If you have assistants, I will send you this handout. And again, I'm going to show you in a minute where you can get all of these slides. But they can answer phone calls. They can upload your listings to an MLS service. They can check on the loan status. They can have keys made. They can place ads. so forth and so on. They can monitor files. They can put signs on the property. They can arrange dates and times for inspections. They can do physical maintenance, so forth and so on. Here, however, is what they may not do. They may not prospect for you. They may not make cold calls by telephone or in person, or otherwise contact the public for the purpose of securing prospects for listings, leasing, sales, exchanges, or property management. Your unlicensed assistant may not hold open houses or have information at any sort of trade show. They cannot prepare promotional material if it is not approved by the licensee and supervising broker. They can't show property. They cannot answer questions on title, finance, or closings other than the time and the place. They can't answer questions about the listing other than the price and the amenities. They can't go through and explain the contract. They can't negotiate commissions. They can't discuss with the owner of real property the terms and conditions, so forth and so on. All of these things you need a real estate license to do. All right, in the last 10 minutes, I'm going to cover advertising rules and licensees acting as principals. A lot of the licensees acting as principals have to do with if you have a rental property and security deposits. We covered all of that under handling the escrow funds. But let's talk about advertising. The last time this was revised was in 2014. And basically, advertising means any and everything you do to market yourself. Look at me, look at me. I'm a real estate agent. I'd love to help you with your needs, and to market a property. This is a property for sale. This is a property for lease. This is a property for exchange. Any media falls under these license laws. So any manner, method, or activity that you use to let them know about yourself or a property for sale or for lease. It includes print, photographs, broadcasts, internet, newspapers, magazines, flyers, business cards, billboards, radios, videos, television signs, directionals, Twitter, TikTok, YouTube, Instagram, Facebook, newsletters, voicemail, faxes, emails, any type of social media, including text messages, banner ads, pop-ups, any kind of advertising. Any advertising that is misleading or inaccurate in any material fact or in any way misrepresents real estate is absolutely prohibited. It all must be done under direct supervision of the broker and in the name of the firm. A licensee shall not advertise any real estate for sale unless the licensee has first secured the written permission of the owner. When such permission is granted, a licensee advertising real estate that is listed with another firm shall clearly and conspicuously disclose the name of the listing firm unless they have expressly agreed to waive those clear and conspicuous disclosures. A licensee shall not advertise to sell real estate when the advertisement is directed at or referred to persons of a particular race, color, religion, sex, handicap, familial status, or national origin. The contents of any advertisement must be confined to, as we saw in the video, describe the property itself. And any advertisement that is directed at or refers to a person of any particular race, color, religion, sex, handicap, familial status, or national origin is prohibited. Any advertising on the internet by a licensee shall disclose the name and telephone number of the firm on every web page. So this is not your social media. This is all of your agent web pages. You have to have the name of your firm and the phone number of your firm on every page of the website. If you are advertising, so other types of internet advertising, i.e. Facebook, Twitter, TikTok, Instagram, YouTube. When advertising in electronic messages of limited information or character, The licensee shall provide a direct link to a display that's in compliance. In other words, on your Facebook post, for example, you don't have to be in full-blown compliance if you're describing a property, but you have to have a hyperlink where the public is one click away from getting to either yours or your broker's website that is in full-blown compliance with the all this information of these license law rules, advertising rules. When advertising real estate for sale on an internet website not owned or controlled by you or the firm, i.e., Zillow, Redfin, Realtor.com, Trulia, Homes.com, those are not controlled by you or your firm, and that website's term of use limit the licensee's ability to comply with this paragraph, the advertising shall provide a direct link to display that is in compliance with this rule on every viewable page. Information on a website maintained by a licensee that is outdated shall be updated or removed within 30 days. In other words, on a website that you control or your broker controls, if a property is showing as active, but it's actually under contract or sold, you have to remove it within 30 days. Obviously, you don't have control over Zillow, Realtor.com, those other ones. If you are made aware that a listing that you had is showing on one of those public websites is still showing as active when it's not, you can't do anything about it, but license law says you need to be able to demonstrate that you reached out to Zillow, Realtor.com, so forth and so on, that information is inaccurate. In other words, a licensee who provides timely notice shall not be in violation of the rule. All right. For the name, it can be a trade name. So a lot of our brokerages operate under a trade name. So there's a trade corporate name, and then there's a trade name. So you can advertise either under the corporate name or the trade name, because the trade names have to be registered with GREC. Now, if you are advertising a specific property for sale, the firm's name shall appear. Let me see. Hang on one second. Okay. I've got an easier way to show you guys this instead of on the slides. So let me show you this document here. I think it's easier to see because I have it in outline form. So this is what we just talked about. All advertising. So there's two kinds of advertising. Again, look at me. I want to help you with your real estate needs, or this is a specific property for sale or lease. So both types of advertising may not be misleading or inaccurate, may not discriminate, must be done in the name of the broker, and that's the firm, not the person, in a manner reasonably calculated to attract the attention of the public, and reviewed and approved by the broker. Now, if you are advertising a specific property for sale, it is required the brokerage name and the brokerage phone number as registered with GREC, and the broker's name must be in the same or bigger size, frequency, and prominence as that of the agent, as well as the phone number. What does that mean? For a house for sale, you can't have ABC Realty in size 172 bold font, and you can't have property for sale, Dana Sparks, 172 bold font, my cell phone number, 172 bold font, and then my company's name and phone number in size 50, elite Pica font and phone number. Size, prominence, and frequency means it must be in the same font size, bold or not bold. If I have Dana Sparks, Dana Sparks, Dana Sparks, I have to have ABC Realty, ABC Realty, ABC Realty. And it's optional to have your name or your team name and your phone number and your email. This is when you're marketing a specific property. If you are marketing yourself, Dana Sparks, greatest real estateist agent in the whole wide world, my cell phone number. I'd love to help you with your real estate needs. Let's talk. I can have Dana Sparks, Dana Sparks, Dana Sparks. I can have ABC Realty. It doesn't have to be the same number of times. I can have my name bigger. The company's name can be smaller, but it must be in a manner reasonably calculated to attract the attention. So this same size, prominence, and frequency, that's just we're advertising a specific property. I don't even have to have my broker's phone number on any marketing I do of myself and my services. Per license law, your broker may require you put their phone number on everything, but license law does not, just on marketing a specific property. And if you own a property, again, you must disclose in any and all marketing that you are a licensed agent in the state of Georgia, and you must get your broker's written consent and approval of how you do that. If you are an inactive agent and you are selling a house, buying a house, renting a house, leasing a house, obviously you don't have a broker that holds your license, but you still have a license. It's just inactive. So you inactive agents, you must still put that you hold a Georgia real estate license. Now, electronic marketing. On your websites, every page must have the brokerage name and phone number. All other electronic marketing, again, you must be one hyperlink away from the public getting to something that is in full-blown compliance. Now, what about your broker's address? Nothing in license law requires anything about an address being on any marketing, but your broker may have a policy. What about business cards? Must meet the terms of all marketing, and it doesn't have to have your broker's phone number unless your broker requires it by policy or that card is ever going to be held in a listing. And there are some resources. There were a bunch of proposed rule changes regarding teams. All of that got knocked down, and so I'm not going to cover that. So that is on all of these slides. That is advertising. And then just lastly, agent as principal. Give me 2 seconds and we will be done. Basically, if you are buyer, seller, landlord, tenant, you cannot do anything with respect to real property without notifying your broker in writing and gaining their consent. And this is what it says. This is what the license law says. No licensee shall be permitted to list, sell, buy, exchange, rent, lease, or option, or offer to list, sell, blah, 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 real estate, either in an individual or multiple parcels, in the licensee's own name or in the name of any like LLC or company or entity which they are an officer, employee, beneficiary, or member of such firm or entity, without first advising in writing the broker for whom the real estate licensee is acting. When a licensee offers to buy a property as a condition of getting a listing agreement, or in which you're extending the expiration date, you must enter into a written contract to purchase, which expresses all the terms and conditions of the purchase prior to or at time of entering into the listing agreement. Similarly, when you offer to buy a property, same thing. You have to put everything up in writing. Licensees advertising to buy, sell property for their own accounts must comply with all the advertising rules we just talked about. Bottom line, in order to protect the public, Georgia law requires a licensee to comply with its provision, whether you're acting as an agent for somebody you're not related to, or if you are acting as an agent for yourself as the buyer, seller, landlord, and tenant. And brokers are required to review all of the activities for compliance with license law. In other words, you cannot do deals for real property outside of your broker. Property management, we've talked about this when we talked about trust money. when you can hold trust money and when you can't hold trust money. This is just a reiteration of all of this. And that's what we have already said. You must advise your broker in writing, and license law requires brokers to review all of their affiliated licensees to be in compliance, whether you are acting as an agent for somebody else or for yourself. So why do I have to tell my broker I'm marketing a property that I own if I'm not paying a commission? Again, it's Georgia law. In order to protect the public, it requires a licensee to comply with its provisions, whether acting as an agent or a principal. We've talked about that for inactive. And woo, we made it to the end. Again, remember to confirm all law questions with your broker and GREC and all contract questions with your broker. Please attend additional courses. This has been the school, Real Estate Academy of America, GREC School 6915. These CE credits will be recorded within 3 to 5 days. I do have a YouTube video, YouTube channel with video contract tips. Please type in your name, email address, and license number. And I am so grateful and humbled by your kind remarks, especially at the beginning of this class. I appreciate your time, and I will stay on board to answer any questions. I'm going to stop the share and answer any questions anybody has. You can unmute yourself because or type in the thing. Cheryl?
Dana, I just wanted to add a comment if it makes you feel any better. I wasn't planning to take this class. I think you saved me from a huge advertising mistake.
Okay.
I'm making corrections to after this class. So thank you.
Thank you. My pleasure. Thank you, Jasmine. That's sweet. I appreciate it. Anybody else? Any questions? All right. I'm gonna stop the recording for a minute. Where did it go? There we go.